Okay, so now we're in dormant commerce clause. Okay, so let's get through this like efficiently and effectively. So again, the way that we're going to be able to do that is to like just be on the same page. Just make sure we're paying attention. Let's make sure we're ready. We're putting preemption behind us. I'll give you guys a last like minute to write your last few notes, and let's start off fresh with dormant commerce clause. Let me get situated. Okay, so I think again, what's going to help with all of con law is starting off with a translation, right, and an understanding in your own words of what this doctrine is all about. So the first thing is from a folder system perspective, we know dormant commerce clause goes where. Let's go with do that after. Yeah, thank you. Let's go with Shane. Where does dormant commerce clause fall within our folder system? It's one of the.
So was the law within the state's power?
No, it's not within source of power. It's within.
Like second level or?
I'm saying like what it's one of four ways to do what? It's one of four limitations on the state's power. So dormant commerce clause, first off, we want to see is a limitation on the state's ability to pass laws. So again, who's going to be arguing the dormant commerce clause? The person trying to shoot down the law. We've seen some of these words before. This is called the dormant commerce clause. We've seen the actual commerce clause before. So remember, this is a source of power for Congress. The dormant commerce clause is a limitation on states. Okay? A limit on states. Commerce clause is a source of power for Congress. Let me kind of show you the relationship between these two and how that works, guys. Commerce clause is within the powers of the federal government. What is their purpose and vision for commerce? It's a flowing interstate commerce, right? Where goods and services are flowing through the states in a way that you don't have any particular state that is just like cannot survive on its own, doesn't have goods and resources to thrive, etc. It's like, no, we should share, we should move things so the country as a whole can be, right, in a good place. Well, the dormant commerce clause is something that's put into place to prevent states from messing that up. Because you can imagine if states wanted to, certain states, not all, they could pass laws that just protected themselves and their own economy. Esteban, can you think of a state that would likely be okay without having to do much business with the other states in the country? Texas, and I would say probably California, right? Two states that are large, two states that have like weather conditions that vary amongst this large land so that produce and things of like that vary enough as opposed to like, all right, you live in a place like New York, super small, and you got either really hot weather, really cold weather. They're very dependent on other states. Ain't no avocados growing in New York, right? So with that said, just imagine this kind of storyline for a second. If you didn't have something like the dormant commerce clause in place, states like California and Texas can start to discriminate against other states. They can say, hey, we're only going to do business within our state. If Esteban, if they only did business within their state, what would that do for the economy of California?
It would probably limit it, right? Because we have a lot of people that are getting produce and stuff from our state. So I think it would hurt both us and the federal.
Well, here's the idea is that if you do business only within your state, Esteban, you're actually going to raise it because you're circulating the dollars only within yours and you have enough people to do so. So if you've already got enough money here, we're making enough money. So it's like if schools are buying their dairy from some California farmers, some Nevada farmers, some Texas farmers, right? Well, the idea there is in if we said, no, we're going to spend all of our money on California farmers only, now California farmers have more money. Now California farmers are spending more money within the state, right? So it's the whole idea that if states could, but only states, obviously, again, like these bigger ones, where they have the amount of people and the resources to do it, it's that when you do things like this, you are protecting your own economy. All right. Now, with things like that, when you are doing things that protects your own economy, what are you then doing? You're hurting other economies. So if we passed a law that said that you must buy all your dairy from California farmers, well, that's helping out California's economy. That's helping out the profession of farmers in California. But it's hurting the Nevada farmer who doesn't have many businesses to sell in Nevada because it's not as big of a state and can no longer sell in California. So that's kind of like the opposite side of it. And so that's why you have the Dormant Commerce Clause. It's to prevent states from doing things like that that will help themselves but hurt the whole. Okay, so that's our nice little big picture to understand what this is all about. The Dormant Commerce Clause, which is, in other words, states do not mess with interstate commerce, right? Do not mess with interstate commerce. Now, let's go ahead and go to our chart. Let's get out of our blueprint. I can see there, right? It's a lot of material, a little daunting. Let's start off with our chart and see how this works for Dormant Commerce Clause. So here's how you want to think of this. Once the Dormant Commerce Clause is triggered, the law must pass the Dormant Commerce Clause test in order to not violate the Dormant Commerce Clause. So you're running this statute by the state, right? So if it's California requiring all schools to buy their dairy from California farms, is that statute going to satisfy this test? This test has two major hurdles. Number one, the hurdle you ask yourself, it's a question, is or does the state law discriminate against out-of-staters? All right, so discrim against out-of-staters. Esteban, looking at that chart, can you tell me what the second major question is going to be?
Does the state law unduly burden interstate commerce?
Exactly. Unduly burden interstate commerce. I know that chart has some more details, but let's look at this first from these two levels, right? At the end of the day, you're going to have to satisfy this question and this question. So if you do not discriminate against out-of-staters, then this is satisfied. What you'll learn in that framework here in a second within number one is that you can discriminate against out-of-staters under some circumstances, but then it must meet some rules. But it's tough. Once you're discriminating, chances are you're going to violate Dormant Commerce Clause, but they will allow discrimination in some situations. So they have basically like exceptions, more or less, right? Then you have unduly burden, right? Do you think you're looking for this to, yes, unduly burden or not unduly burden in order for it to be constitutional, Esteban?
You do not want it to unduly burden interstate commerce.
Right, so pretty straightforward. And so if it does not unduly burden, then this is satisfied. So when you get here, this is just basically like a balancing test, right? Of what is the benefit to the state and what is the burden to interstate commerce. And if the burden is too large, well, then it unduly burdens interstate. Okay, so we should be getting this, right? So again, quick recap on that big picture understanding. If you are the state, and you're trying to have your law be constitutional, it's better if you do not discriminate against out-of-staters at all, because this first prong will be met. But Esteban, are there times where this first prong will be met even if the state is discriminating?
Yes.
Yes, there are times that this first prong can be met even if they're discriminating, and there's two ways, categorical ways to do it. Either one, you meet the scrutiny test, or you meet one of the listed exceptions. And really, in theory, I might consider rewording this, or actually I'll just teach it this way because you don't consider this to be an exception, but really you could treat all of these as an exception of like, if you are discriminating, you can get away with it if any of these are met, one of these exceptions, or you satisfy the scrutiny test. But it's really kind of like not presented traditionally in that way, but that is the function of how this works. All right, you can discrim if you can prove it meets the scrutiny test or there's an exception. All right, so that's it, right? That is your framework. That's the biggest step for dormant commerce clause, is just understanding the lay of the land. Once you get into the actual rules and the analysis, it's not that bad, right? It's a little bit more straightforward. I will say, guys, this is the first time that I am mentioning a scrutiny test, right? Esteban, quick, what are the 3 traditional scrutiny tests that we're familiar with in con law?
Is it reasonable? No, it's intermediate scrutiny.
Throwback. Come on, we worked together on con law. I know it's deep in
I
there.
know. I also totally bombed that final, so that's why I have like PTSD. Yeah, I don't remember past intermediate. Sorry.
Strict scrutiny, intermediate scrutiny, and rational basis review. So we know those are 3 scrutiny tests that we're going to see come up often, but do realize that a lot of sections have hybrid tests that are versions of that. We're not going to focus too much on scrutiny tests right now. We just need to know that they come up in multiple areas of con law, and it's a test that you're running the law through, right, to see if it meets that test. So let's just know that for now. We're not going to focus on the analysis of it. We're going to do that later when we get to individual rights. But for now, just know we do have a scrutiny test here, in which you would analyze the 2 parts to that scrutiny test as you do with all scrutiny tests. All right. So let's now just kind of get like a gloss over of what these exceptions are. And then we can start going through some examples for it. So the scrutiny test that we have, if you're now looking at your blueprint, is the state law is necessary to achieve an important non-economic government interest. The state law is necessary. Necessary meaning whatever your government interest is, this is the only way to do that. There is no other less discriminatory way of doing it. And then what are you trying to achieve? An important non-economic government interest. All right. So there's no rule for that. You have to just analyze based off of whatever the fact pattern is. What are they arguing the government interest is? And so as a precursor to like analyzing scrutiny tests, whenever you're analyzing government interest, the government is always trying to make it as Miss America as they can. This is for public safety. This is for public health. This is for the morals of the community, right? So you're trying to find this big, like overarching, important thing that you can put into this government interest to make it very important, right? But when it's simply in the context of dormant commerce clause for the own protection of your own economy, that's going to be bad. That's going to typically violate this scrutiny test, okay? Whenever you have, and that's where the term comes in, economic protectionism, where you're protecting your own economy, that typically is going to violate the dormant commerce clause. Okay. Also, too, Esteban, just out of it just popped in my head. Remember how I was telling you, like, if you keep all the money within that one state, and I was saying, like, is that good for the state or not? It just popped in my head. Think about how they talk about that with like different races, and you create like wealth within the race, like you circulate that money within that race more instead of spending your money elsewhere. So if that kind of helps connect that, it's like, oh, if you spend all your money within the Latino community, all the Latinos do that. Well, I stop spending my money in the other communities. Well, then that brings up ours, right? So It just popped in my head that can help from that perspective. All right, so that's the scrutiny test. And then lastly, we have the exceptions. If we're looking at the blueprint, Shane, can you tell me what are the 3 exceptions to the this first prong?
Yeah, it's market participant, congressional approval, and traditional public concern.
Traditional public function.
Function, yeah.
Yep. And so with these 3 exceptions, again, making sure we understand all of this. Who's arguing this who's arguing the exceptions? The proponent of the state statute or the adversary, the opponent to the state statute?
So the proponent of the state statute probably would be the state.
Exactly. So the state's going to argue the exceptions because if the exceptions are met, that means this first prong is satisfied. If the scrutiny test is met, this first prong is satisfied. If there's no discrimination at all, this prong is satisfied. So just think of that, right? Take that note down on your chart even. I think that's pretty cool the way we just did that. There are 3 ways to satisfy this first prong. 1, there was no discrimination at all. 2, there was discrimination against out-of-staters, but the scrutiny test is met. And then 3, the first prong is satisfied if there is discrimination against out-of-staters, but the exceptions are met. All right. And then we have the list of the exceptions. Let's see these in action. Let's go through our hypos. All right. So we have the first hypo. California passes a law that requires all schools in the state that provide food to their students to buy their dairy from California cows. California passed this law because it is trying to incentivize more people in California to become farmers. This law would increase the demand and salary for California farmers. George owns a private school in Brentwood and purchases his dairy from Seattle. George files suit to strike down the California law, claiming it violates the negative implications of the Commerce Clause. Okay, so let's go, Shane, one more time with you. So let's go to this. Let's ground ourselves. So we have the California law, and again, it's saying all schools who provide food must buy their dairy from where?
From California farmers.
From California farmers. All right, and then who's your challenger here?
George.
And so George owns a private school in Brentwood. All right, and he purchased his dairy from Seattle. So he's a private school. He gets his stuff from Seattle. Okay, and then now he wants to strike down the California law. Just make it clear real quick. Why does he want to strike down the California law?
Because it's discriminating against out-of-staters.
But from a personal interest, why does he want to strike down the California law? So he can resume doing business with the Seattle. Right now, California is preventing him from doing his business with dairy farmers in Seattle. He needs to strike this law down. So that's again kind of just like a why the party's upset and what do they want? Still applying those same principles to con law as well. Now, so in order to continue doing business in Seattle, he's got to shoot this law down. All right, so we ask ourselves, what type of law is this? Well, it says California passes a law. This is a state law. So we ask ourselves, did California have the power to pass this law? Well, this is likely within the 10th Amendment. Nothing to say it's not. 10th Amendment typically is not a focus on the essay or the MBE. Whenever it's state law stuff, you're typically going straight to the limitations. So then here you have to see what grounds can George invalidate this state law. Are there any grounds for talking about preemption?
Probably not.
Not probably not. Are there any grounds for talking about preemption?
No.
Absolutely not. What must you have in your fact pattern to talk about preemption, at least in a detailed manner?
You gotta have some federal statute.
Exactly. You need a federal
Contract.
statute. So that one's not here. So, I can mention preemption quickly, but there's nothing to talk about. Then we get to dormant commerce clause. What for you is a trigger, Shane, in this question as to why dormant commerce clause is coming up?
Well, so California is passing a law, and you have this guy that's buying his stuff from out of state, so it's clearly like a state law. That's not federal law, so it's probably going to be some kind of dormant commerce clause analysis.
And I'm going to go just a step further and like a bigger picture, Shane. I want you to see that you have a state law that's negatively affecting interstate commerce. And that's how that would be my initial trigger. And keep that line in your head is that that's what dormant commerce clause is, that you're negatively impacting and affecting interstate commerce. Here, you're requiring all schools to get their dairy only from in-state farmers. So that means you're preventing them, as we see with Georgia's issue, from buying dairy from other states, right? That's an interstate commerce issue, right? Because now you're hurting dairy farmers in other states. All right, so that's how I'm triggering this. So then now I need to simply go through my framework. The first question is, am I discriminating against out-of-staters? I think there's a pretty easy answer to this question here. Let's spread the love. Let's go with Lily. Lily, am I discriminating, or is California discriminating against out-of-staters?
I would say yes.
Is that a question?
Yes, they are.
Yes, they are. Exactly. They're discriminating against out-of-staters because they're on its face saying you must buy from California farmers. So there is nothing more clear as a discrimination against out-of-staters than an example like this. All right. There's times where you will discriminate against out-of-staters, but it's not done on the face of the statute. It's not saying by definition of California versus non-Californians and stuff like that. This is like super clear, guys. So never second guess something like this. This is a discrimination against out-of-staters. Out-of-state farmers can no longer sell to public or to schools in California. So therefore, since this does discriminate against out-of-staters, yes, it does. The only way it'll make it past prong one is if it satisfies the scrutiny test or if it falls within one of the exceptions. Now, again, you guys need to get comfortable with like flowing through this and making the arguments. For the sake of time and us understanding everything, we're just going to go through this a little bit more in an abbreviated manner, or I'll do it quickly at least. When you get to this, right, the first thing you have to see is, do I have an important government interest? Right? The state of California is going to try to say, yeah, we do have an important interest of increasing the demand and supply for farmers within our state. However, that's going to be a quick losing argument. The challenger's argument is going to be that this is simply an economic protectionism. This is not a non-economic interest, and this does not rise to the level of important. So again, you're going to be bringing up within this argument the challenger's argument that this is economic protectionism. And that's just like the strong argument that you have to get at when it's present in your scrutiny test analysis. And then also, is this necessary? Even if this was an important government interest, is this law requiring all schools to buy from California farmers necessary to have more California farmers? No. You could have more California farmers by doing a new tax incentive program where you're giving tax breaks to those that switch to the profession of being farmers within the state of California. That can incentivize them in a way where you're not discriminating against out-of-state farmers. So as you'll learn with those scrutiny tests, whenever you're doing like that necessary part or substantially related part, you're analyzing another way they could have achieved the same thing without being as discriminatory. And so here you had one. And then lastly, you would get into any of the exceptions. Does anybody think any exceptions are triggered here? Go ahead and raise your hand and volunteer if you do, and I can work with you. Tamar, what exceptions do you think are triggered here?
The market participant.
Exactly. That's really the only one that's triggered here. Do you think this is going to be application, yes, of the market participant exception?
Yes.
So it's actually not
Oh, no. Okay. Yeah, no.
So yes, this is actually not. No, I said no. I know you didn't do it based off of me. It was just timed that way. But look, so this is not going to work for that, right? So here's the idea of the market participant exception. Tamar, if you decided right here today that you only wanted to buy your dairy from California farmers, are you entitled to do that?
Yes.
So what the market participant exception is saying from the buying perspective, because there's also the selling perspective side of this, but from the more tested buying perspective, is that the state also has that ability to do that. If the state decides today, hey, we only want to buy from California farmers, that's my choice. But in order to fall within this exception, the California statute must only be directing state conduct to fall within that exception. Here, it says all schools. And in fact, we have a private party who's being obligated to also do it. So that's not you doing that. That's Tamar saying, hey, I'm only going to buy from California farmers. And now she's forcing Shane and Lily and Esteban to also only buy from California. No, that's not market participant anymore. But if the state were to say it was only public schools only, public schools are state entities, you're no longer regulating private conduct too in the regards to buying something, that would be market participant. That makes sense, Tamar? Good. You'll also see that later in an essay. I think for the homework essay, we'll learn about how you can see that from the seller perspective. And we'll see seller perspective to the extent that, there's some local businesses and whatnot that will give preferential treatment to locals and to citizens of their state. So, you go to this bar and, if you're a citizen of our state, we give you half off on drinks and things of that sort. So there's also the market participant exception from that perspective. But let's pause on that. It's not as tested, and we'll see that in our essay tomorrow. So no market participant. The second exception, Tamar, is congressional approval. So literally, we have to have Congress actually say, hey, California, I see what you're doing. I'm okay with it. I approve it. Do we have any facts of that happening here, Tamar?
No.
The only way we would know Congress approved is if the facts say Congress approved, right? That's the only way. So you don't have to overthink that exception. You just need facts for it. And then traditional public function, right? So traditional public function is an exception saying this is an area that we've traditionally allowed the states to be a bit discriminatory in this way, right? So if we go to the blueprint, let's see if we had some examples in there. Traditional public function, the example that we gave, public universities that charge lower tuition to in-state citizens. Well, that is discriminating against out-of-staters. You're making them pay more than the people in-state. However, that's something that's a traditional public function, right? And so, we've allowed that for this long. It kind of fits into that category. You can't just throw new things into traditional public functions. Not tested that often on the bar, so just know it's an exception. You can mention it as a rule, but typically it's not met because it's a vague category of what actually fits in there. Okay.
That'd be like Texas's power grid, right?
I have no idea what that
Like
is.
Oh, all right, never mind.
All right, never mind. I am under a rock.
We could go through it. Texas has its own power grid that it only uses for itself, and that's traditional, and they don't share it with anybody else. So it's traditionally a public function. So they're able to have their own power grid.
Damn, Texas.
That's East Coast and Texas.
What?
That's why they have that. Yeah, it's west. There's an eastern power grid. There's a western power grid in just Texas, and then that's why they had that big power outage and the freezing and
With the snowstorm.
Yeah.
Fun.
So I was wondering how they're able to do that, but it's probably because it's a
Traditional public function. Damn. Fun fact of the day. I did not know that. Damn Texas. All right. So, there we go. So those are your exceptions. And we kind of went back into detail with them on this hypo. But let's make sure we zoom out now and finish out this hypo. So, Tamar, walk us through real quick. Was there a discrimination against out-of-staters?
Yes, there was.
Was the scrutiny test, so therefore, it's only going to make it past prong one if it satisfies the scrutiny test or there was an exception. Was the scrutiny test satisfied?
No.
And the main reason why it wasn't is because this was an example of,
Economic protectionism.
there we
That
go.
does not rise to the level of importance.
Exactly. And then were any of the exceptions met?
No, because under the market one, the market only applies to the state's power. So if we change the facts to public schools, then it probably would have applied.
Good. And then it didn't meet the other two as well. So then from there, we know at this point, what about prong one?
It's satisfied.
No. It just
Wait.
it discriminates, yes, against out-of-staters, and no scrutiny test is met, no exceptions are met. So prong number one fails.
Okay.
Right?
I thought it is successful because it is discriminating,
Well,
and there is exceptions. That's how I'm thinking.
okay, so it's totally fine depending on what perspective you want to look at it from. If you're looking at it from the perspective of the challenger must prove one of these things to show that it's violated, or if you want to look at it from the perspective that this state law must meet these prongs in order to be constitutional. So that's only where your difference is. And so I'm looking at it from like the state law has to prove these things to satisfy this. And so in order to satisfy the first prong, right, it has to be either no discrimination against out-of-staters or yes. All right. So you get what I'm saying?
Yeah, I got it.
So it's all perspective. But as long as you know that this is in favor of yes or no constitutionality.
This is in favor of unconstitutionality.
As long as everybody, whatever perspective you're taking, as long as you connect it to that after going through prong number one, we now know that this is going to be unconstitutional. All right, so then you would do question number two. In a hypo and in an essay like this, number two is just kind of like, going through the motions at this point to finish off the analysis, but you already have the outcome based off of prong number one. But you would still go here and you would weigh, right, the benefits and the burdens to interstate commerce and the benefits to the state. So you're going to, guys, in con law and some other classes too, you have to know in certain sections when you will be using the same facts as you just did. And you need to get comfortable with that because sometimes it's an uncomfortable thing to do to use those exact same facts. And so typically you are going to use the exact same facts, but from a different angle because the rule is different. But here you're going to be talking about, well, the benefit to the state is simply economic protectionism for them to have more farmers. And that's not a very highly valued government interest here. And what's the burden on interstate commerce? Well, this is going to prevent access from all these farmers out of state from being able to do business in California, which is a very large state, right? Which will have a very significant impact on this market for dairy. And so, therefore, this does unduly burden interstate commerce, right? So again, it's just like it's all a balance. And here, considering the interest is given so little value because we don't like economic protectionism, it doesn't take much to then unduly burden interstate commerce. Awesome. You guys are doing a great job. Keep it up. Honestly, you guys are doing well. We're almost done with Dormant Commerce Clause in this section. We'll be taking our break soon, so let's just keep it up. So let's go ahead and do number two. I'll take the reins on this one and just kind of walk us through quickly because I think we understand how this works now. So this is a variation of hypo number one. There has been a nationwide outbreak of Ebola in the U.S., spreading through cows and dairy products. In a state of emergency, Congress enacts a statute that permits every state to pass dairy laws necessary for the safety of their residents. California has screened and tested all of the cows in California, and there is no trace of Ebola in California cows. So California passes a law that requires all cows. California passes a law that requires all public schools in the state that provide food to their students to buy their dairy from California cows so they can ensure nobody gets sick. Sally is a farmer from Seattle who sells dairy to California public schools. Sally files suit to strike down the California law, claiming it violates the negative implications of the Commerce Clause. Again, giving you all this variant wording. Make sure when you're doing all these hypos, you're getting comfortable with all this variables and how things are worded, and you can translate it to how you like to think about it. So will Sally be successful? Tamar, real quick, what do you think? Different outcome here on Dormant Commerce Clause, yes or no?
Yeah, it's gonna be a different outcome.
Lily, what do you think? Real quick, different outcome, yes or no?
Yes.
Yes? All right, last one, Shane, real quick, different outcome, yes or no?
Yes.
Awesome. So you guys are now starting to get the feel then of Dormant Commerce Clause, right? What was the big fact change in this hypo from the previous one? Tamar, what was like the essence that changed from this hypo, in the previous?
It was no longer for economic use. It was to prevent the outbreak of Ebola, which is like a health concern of the people, emergency situation.
Exactly. So we need to realize the impact of that from this big picture level and how that's going to change everything. Let's go through this. Let's go with Max. Max, do we still have discrimination against out-of-staters?
Yes, there is.
So the only way we're going to get past prong one or satisfy prong one for the statute is if the scrutiny test is met or the exceptions. Remember, if this answer is no, you don't have to go through any of that. But if the answer is yes, you now must go through those questions. Do you think the scrutiny test is now going to be satisfied?
Yes, it will be.
Exactly, because now the important non-economic government interest is now what?
To prevent the spread of Ebola.
Exactly. So you're always going to make that as Miss America as you can and call that public health and public safety. So yes, you have that. And is this necessary? So this is the analysis part of the scrutiny test. You could go either way. You could come up with another creative way that California could still ensure the safety without just making an absolute ban on all outside cows, right? Because their whole thing was like, we tested our cows, ours are good, so let's just stick with our own. But if they were able to test their cows, right, in theory, you can make the argument, well, they could test the dairy products as they come in from other states. However, that could be very burdensome, and it's a crazy time right now, so maybe that won't be required. But if your brain is working right, when you're getting to the necessary argument, you're trying to come up with another way that's less discriminatory. And an easy one to say is that they can use their same testing methods for other states or as it comes in, something like that. But likely, the scrutiny test is likely met. Exceptions. Does the market participant exception apply here?
Yes, it does.
First off, do we need the exceptions in theory?
No, because the strict scrutiny. Because the test was met.
Exactly, but we still got to go through it. And then we have here market participant, likely yes, because in this fact pattern, it did say all public schools. So it limited it to just its conduct. So market participant now applies. Was there congressional approval?
Yes, there was. The Congress enacted the statute.
It permits all states to pass laws necessary for the safety of their residents. That was congressional approval. Is this an area of traditional public function? No, still not, right? But listed as a rule. So it's like, however you want it, this first prong is going to be satisfied, whether it's strict scrutiny, market participant, or congressional approval, right? So super strong argument for satisfying this in favor of constitutionality tomorrow, however you want to look at that. And then lastly, you have unduly burdened. And there you're just going to use the same arguments that you used more or less in your scrutiny test to say here, there's a high benefit to the state here by protecting the lives of their citizens. California knows their cows do not have Ebola. They can prevent their citizens from getting Ebola with this statute. So a very high benefit to the state. And the burden on interstate commerce, right, it can be, significant to an extent that you're not allowing other states to come into California to sell their dairy. And California is a big state and probably responsible for a lot of out-of-state sales in that way. But under the circumstances, right, this is all in favor of not unduly burdening it because this is all for safety in the life of people. All right? So from that perspective, this prong will likely be satisfied as well. Therefore, this statute will be constitutional. Sally will lose. Tamar, question.
Is it a fair argument under the unduly burden to say that it might just be for a temporary time until the Ebola is gone? Or is that doesn't really matter?
Oh yeah, I don't think it's necessary for this fact pattern, but if they gave you something like some additional facts and a whole different feel to this question, where it was like, all right, this is now like 3 years later, Ebola has been completely erased, and yet we still have this, like, yeah, like it could be grounds for that. So I think if anything, that was something that you could attack in the necessary discussion. Is it necessary to make a complete ban with no time restriction until this passes over? Something like that. But knowing the traditional flow of this, like you can make that creative argument, but under the circumstances, this is fine for now. Clarence?
I know this is frivolous because the other exceptions were made, but for the traditional public function, couldn't you make the argument that it is the state's function because it's only public schools to feed the students at public schools?
Well, what you're looking for is traditional public function to discriminate in this way. So that's why it's like traditional public function to give lower tuition rates, right? Or to not share our electricity with other people, etc. So in that regard, yeah, that's how you look at that. All right. So that's number 2. Okay, so then last, I just want to read number 3. And we're not going to go through the answer. I just want to show you how it's an example of something. All right. Let's go with Arthur. Arthur, can you do me a favor, man? Can you read number 3? I'm going to take a sip of water.
Aloe vera products are made from either grade 1 aloe vera plants, grade 2, or grade 3. Each grade is clinically safe, and the additional benefits between each grade are minimal. Texas passes a law requiring all aloe vera products sold in the state must be made with grade 1 plants. Texas happens to be the #1 producer of aloe vera plants because the plant thrives in their unique weather patterns. Only 2 other states produce grade 1 aloe vera plants, whereas every state produces grade 2 and grade 3. Allison makes aloe vera lotion in Florida and sells them to boutique stores in Texas. Since this new law, she has been unable to sell in Texas because she only has access to grade 2 aloe vera plants. Allison brings suit to strike down the Texas law. Will she be successful?
Perfect. So guys, ears up, eyes up, right? Attention here. This is a very common scenario where you have a facially neutral but yet still discriminatory law. All right, so let me explain that. But if you guys can get this down, this will really help with some of your issue spotting on these con law essays. What is the state law here, Arthur?
The state law is that Texas will only sell or produce the aloe vera 1, grade 1.
Exactly. Aloe vera 1, okay? And then basically you have Allison who she uses aloe vera 2, and so then she can no longer sell in the state because they require products with aloe vera 1. All right, so on the face of this state law, Arthur, is it discriminating against out-of-staters?
Yeah, it does look like it.
No. So on the face, we want to say it doesn't, right? Because remember,
okay.
right? All the set, they're like, hey, we just said we need aloe vera 1. You know, on its face, it's like, well, anybody can still sell in here. Doesn't matter what state you're from, as long as you got aloe vera 1. So that's what we want to see is the difference between this hypo and the previous one, is that those hypos said you must buy your dairy from California farmers, right? That's on its face discrimination. Here, you want to think of it from this perspective. Texas is like tricky. Texas is trying to economically protect themselves. They know they can't just straight out say you can only buy products from Texas manufacturers or producers, etc. However, what do they know? The facts tell us that aloe vera 1 is Texas happens to be the #1 producer of aloe vera plants because the plant thrives in their patterns. Only 2 other states produce grade 1 aloe vera, whereas every other state only does 2 and 3. So from this perspective, when you kind of know the circumstances, it's like this is a sneaky way of discriminating against out-of-staters, especially when, Arthur, it starts off by saying aloe vera grade 1, 2, and 3 are all clinically safe, and the additional benefits between each grade are minimal. So you're like, I'm not buying it, Texas. You're not really trying to just have aloe vera 1 for some good purpose. You're just trying to discriminate against out-of-staters here. So this is an example of circumstances where it has a discrimination against out-of-staters, even though it's not done on the face of the statute. Do I have any questions on this fact pattern or on this concept?
DeAndre, so if there's an explanation of, like, there's a policy behind it, like, would they throw that in there, like, the state or, you know, whoever passes this law for this public policy purpose, but it's really not a good one? I'm not sure if I'm asking that right.
Yeah, well, I will say that with these type of common law questions, they'll typically allude to why. And yeah, here it's not saying why they're requiring grade 1. And then if they don't, from that perspective, you get to just kind of go based off of, like, you know, they didn't even mention anything, which makes it more likely they're just doing this for economic protectionism. Like, I can't point to
Gotcha.
a good reason as to why they're doing this. Yeah. Awesome, guys. Okay, cool. We can move on from that example. You can go through the full framework, but the key to this question was realizing that your answer here is yes. It does discriminate against out-of-staters, where it didn't appear to do so on the face of the statute. Okay? So let's go to number 4. So this is just a quick example of no discrimination. In efforts to reduce traffic congestion on the highways, California passes a law that prohibits the use of 18-wheelers on the highway within the state. 18-wheelers are commonly used for the transportation of goods among states. What is the strongest argument in striking this law down? So it's like, man, we got too much traffic. So we're going to try to reduce this by no more 18-wheelers within the state of California. So Challenger's going to bring this down as violating the Dormant Commerce Clause. Let's go back to Max with you quickly and analyze this one. Max, is this going to violate the Dormant Commerce Clause? Quick feel, what you think?
Yes, it will.
It will. So even though you don't have discrimination, it will. Why is this not discriminating against out-of-staters?
It's unduly, sorry. I jumped ahead. Because it doesn't discriminate on out-of-staters on the face of the statute itself.
Or even like in a facially neutral way, right? Because this applies to California drivers of 18-wheelers. This applies to outside of California drivers, right? Anybody having an 18-wheeler can't drive it. So there's no discrimination against out-of-staters from that perspective. And so the answer there is no. So you make it past prong number 1 with a no here. But there's 2 prongs. In here, right, you're getting into the burden of interstate commerce. What are the 2 things that we're weighing based off of what the facts are telling us?
What are we weighing?
We're weighing interstate commerce, and now interstate commerce is not being effectuated as smoothly because you're no longer allowing these transportation vehicles to commute through California. That's the burden. And then what are we weighing? The benefit to the state. What's the benefit to the state at hand?
Congestion.
Yeah, like congestion on the highways and traffic. That's not going to be enough. That's going to unduly burden. You can't, for the sake of making better traffic, throw off interstate commerce. So this would likely violate Dormant Commerce Clause. So what did we do here? We did an example of Dormant Commerce Clause being violated because it discriminated against out-of-staters, but it was economic protectionism. Those are traditionally going to violate the Dormant Commerce Clause. The second hypo we did was one in which it was a similar fact pattern, but the interest and the reason why the government was passing their law was different, and that changed everything. So therefore, it was justifiable discrimination against out-of-staters, and it did burden interstate commerce in a way that was not unduly. The third hypo we did was another violation of the Dormant Commerce Clause in a way where the state was trying to be sneaky. They were not facially discriminating, but really they were discriminating with how the facts, right, were situated. And then the last hypo, it was an example that you can still have a violation of Dormant Commerce Clause even if there's no discrim against out-of-staters, if it still unduly burdens interstate commerce, right? You have two prongs, don't forget it. Obviously, a lot of the points and focus is on this first one, but don't forget the importance of this one. All right, Max, are we walking away from Dormant Commerce Clause with a strong, solid understanding?
Yes.
Good.
Yeah.
Awesome. At the very end of this, you have here a couple of quick questions layering the state's ability to impose and cut taxes and possible DCC violations. California, looking to increase their number of in-state farmers, offers a 5% tax break for residents who become full-time farmers. This is likely not going to violate the Dormant Commerce Clause. There's no discrimination against out-of-staters. By giving a tax break, right, that's not discrimination against out-of-staters. Likely not unduly burdensome either. So that would be okay. But what about number 6? They're looking to increase the number of in-state farmers, and they impose a 15% buyer tax on all imported dairy. So what happens? Nobody starts buying dairy from other states because there's like so much more expensive. That's going to be, again, this discrimination against out-of-staters, likely just economic protectionism, likely violated. But you see these questions on the MBE that are focused on taxes and tax breaks, right? So just kind of giving you some comfort level with that and some quick hitters to see how you should be feeling in that gauge setting.